after they bring him in.
Mr. Adam is doing it, not Steel.
Mm-hmm.
Good morning, Mr. Adams.
Your Honor, good morning.
Good morning. Can we bring up Mr. Cook? You go ahead and call him.
Okay. Good morning, Your Honor. Today is March 17th, 2026. This is the 9 a.m. criminal motions calendar in front of the Honorable Tadia Whitner. The first position on the calendar, State v. Billy Joe Cook, case number 18B04071-7. The defendant is in custody. He'll be present in the courtroom, and he's represented by his attorney, Mr. Keith Adams, who's appearing via Zoom, and that's for a renewed motion for bond.
Good morning, Mr. Adams. Are you ready when reached?
Your Honor, good morning. I am ready, yes.
Okay, thank you. We're bringing out your client, but we're gonna call the rest of the calendar, okay?
Thank you, Your Honor.
Thank you.
Next position, Your Honor, State v. Ismael Perez, case number 24B01452-7. And I believe that defense counsel requested continuance in that matter.
Granted.
The next position, Judge, State v. Gustavo Aldolfo Lazalde, case number 26B00639-7. The defendant is present in the courtroom along with his attorney, Mr. Ryzik, and that's for all pending motions.
Okay.
And the last position on the calendar, State v. Damon Jamal Swain, case number 25B02055-7. The defendant is in custody and represented by attorney Sliz, and that's scheduled for a plea hearing.
Mr. Adams, Mr. Cook is here in the courtroom with us, and we'll start with that, please. Yes.
Your Honor's connection to her with the Paris matter being continued, I believe I'm not needed, just want to confirm.
I don't think Mr. Lazalde needs an interpreter, correct? You may. Thank you, sir.
Thank you, Your Honor.
Mr. Adams? Hope you didn't think we had a long calendar. Mr. Adams?
Did I lose him?
I think he was there.
All right.
Yes, Your Honor.
Yeah, we're ready.
Thank you, Judge.
Okay. Mr. Cook, Mr. Adams, as you can see, is here, and, if at any time, Mr. Adams, if you go out, we'll let you know, okay?
Your Honor, thank
All
you.
right. Who's gonna be?
May I proceed?
Yeah, we're here at 18B04071-7. This is the state of Georgia versus Cook. Mr. Cook is now in the courtroom. His attorney again is here by electronic being Zoom. Mr. Adams, your motion ready whenever you are.
Your Honor, thank you. This is a renewed motion for bond. And if I may just take one moment with the court's permission to review a little bit about the history, procedural history of Mr. Cook's case.
Yes, sir.
This is an incident, an indictment that alleges an incident that occurred in 2005. Mr. Cook was arrested on this charge on October the 4th of 2018. Upon motion for bond, the bond was granted on February 26th of 2019. Mr. Cook remained on bond, on that bond, within a plethora of conditions for approximately 5 years and 3 months. During that period of time, there were no violations of bond. There were multiple requests filed by the defense to modify the bond in regards to travel, in regards to work, in regards to attending a funeral, in regards to attending family functions, the bulk of which were granted by the court. While on bond, Mr. Cook was on an ankle monitor. He reported regularly, without fail, to the monitoring company. He notified them, for example, when the ankle monitor was low on battery, when maintenance was required, when he was running late from loads that he would drive. As the court knows, he was a truck driver and owned a trucking company. There were no allegations of any crimes committed by Mr. Cook while he was on bond. There was a motion to revoke his bond that was filed in early 2024. On May the 22nd of 2024, this court heard and granted state's motion to revoke Mr. Cook's bond. The basis of that violation was, of that revocation rather, was a violation of bond condition number 9. Specifically, the court found that Mr. Cook violated the condition of bond that required that there be no ammunition present in his home or his vehicle, whether it belonged to him or not. As the court recalls, there was an allegation that police responded to Mr. Cook's location, his home. After he called the police, he had been shot. He allowed the police into his home. He searched his home subsequent to that call, and 2 magazines were found in the house. He was never charged with anything. He was in fact the victim in that case, in a case that was subsequently indicted against his wife in Cherokee County. He underwent surgery. He lost a finger in that incident. He was actually shot, but nonetheless, a motion to revoke bond was filed by the state, alleging that and other violations. The court heard all of the evidence and made a determination specifically that he had violated that condition, that there be no ammunition in his house or in his presence. So his bond was revoked on May 22nd of 2024. He has been in continuous custody since that period of time. We don't question, or we're not taking issue with the court's finding or the court's order. That is what the court found, and it was noteworthy, however, that he was not charged with committing a crime, that he was himself a victim in that matter. So his bond was revoked. He has now at this time been in jail for approximately 1 year and almost 10 months, so almost 2 years on that revocation of bond. He has been awaiting trial. We announced ready for trial, and the case was heard in regards to motions in August and September of 2025. There were certain motions that were denied, some that were granted, but the case was scheduled to go to trial in September of last year, 2025, and the defense at all times announced that we were ready for trial. We did not want a continuance, and we were being scheduled at that time. we had based upon the rulings made by the court, the state decided to file an appeal. I believe they filed a notice of appeal on September the 15th of 2025. Now, the filing of appeal was discretionary. That was the state's decision to file it. Again, I repeat that the defense's position was that we wanted to go to trial. And it is their right. It's certainly their right to file an appeal on the court's order. But we filed a motion for bond. We asked the court to reconsider his revoked bond. And I believe on September the 24th of 2025, the court issued an order denying that request and ordered that Mr. Cook stay in custody at that time. He has, of course, been in custody since then. The appeal was filed by the state, and the case was docketed in the Supreme Court on or about February 23rd of 2026 this year. The state filed a motion recently for an extension of time to file their brief. We expect reasonably that an opinion from the court will issue sometime in October of this year. By that time, Mr. Cook would have been in custody on a revocation of bond for 2 years and 5 or 6 months by my math. I would stress to the court that we have not done anything to delay this case going to trial. We have exercised our rights and filed the motions we thought appropriate. The court has ruled, we believe, appropriately. But it is because of the state's appeal that this case was not tried in September of 2025 as it otherwise would have been. Now, we're asking you to reconsider the issue of bond and to release Mr. Cook on bond. In your order revoking the defendant's bond back in May of 2024, Your Honor, the court found, and again in the order denying bond in September of 2025, the court found that opined that Mr. Cook was a risk of danger to the community if he were to be released on bond. By way of argument, and I certainly don't intend to argue our case. At some point, we will try this case, and those issues will be vetted at that time. But he was released on bond initially, and I asked the court to consider that he had been on bond for more than 5 years, and had been, other than the delay caused by co-counsel myself being out of pocket for 2 years. He remained ready and always availed himself to the court. Whenever he was required to be there, he was there. Now, the court has the ability to impose whatever conditions the court finds appropriate to ensure that he reappears for trial, and that if there are any concerns about his being a danger to the community, that those can be assuaged. I would ask the court to consider releasing Mr. Cook on bond. If he is released on bond, he can be subject to a GPS ankle monitor. He can be subject to house arrest. In fact, I would suggest that the court impose that condition. If released, he can live either with his wife, or he can live with his mother. I would suggest that he be allowed to live with his mother. He is employable. He has always worked gainfully, and he has always he's owned companies and he has worked for companies. If he is released on bond, he would be able to work with a trucking company where he works as a dispatcher. He would not have to leave his location, so he could be confined to his home at all times. And the court and any monitoring company would always know exactly where he is. I would suggest to the court that would assuage any concerns about Mr. Cook's activities or whether he is a danger to the community. I would also suggest to the court or point out to the court that in the period of time that he had been out on bond before the bond was revoked, he'd never been charged with any offense. He'd never been alleged to have contacted any witnesses or any potential witnesses, any form or fashion. In fact, one of the allegations the court remembers in the motion to revoke bond was that the state alleged that he had made contact with the daughter of the alleged victim in this case. And that was, as you recall, a situation where he and his wife and friends went out to breakfast and happened to be at a restaurant unbeknownst to him where the daughter worked. and that there was no contact, there was no conversation, there was no threat, he left. And so I don't think it's a reasonable assertion to be made that he is a danger to intimidate any witnesses. He's certainly not a flight risk. He's always been here. He has not been convicted of any crimes in decades at this point. And I think the court can impose whatever conditions are appropriate to ensure that he appears for court. Last thing I will say is this, Your Honor. When you revoked the bond back in May of 2024, the court, of course, had concern about the fact that there was ammunition, rightfully had concern that there was ammunition found in the home where he lived. I think it was clear to everyone, however, and also based on the fact that he was subsequently listed as a victim in an indictment, that he was not the one. There's no allegation that he possessed a gun, that he fired a gun, that he had a gun. Still a violation. I understand. I'm not arguing that was not a violation, but I think the nuances or the facts are important. So I'd ask the court to keep that in mind. And perhaps the biggest argument is that we would have resolved this case in September or October of last year. And we were ready to, we remained ready to. His being in custody for essentially an additional year is based on the state's movements in terms of filing the appeal and asking for an extension of time. So, Your Honor, based on all of those and based on that argument, I'm not here to argue the case, but simply that he is amenable to bond, that he is a good candidate for bond, and I ask you to consider releasing him on bond at this time with whatever conditions the court believes appropriate to have him reappear.
May I ask you a question, Mr. Adams?
Of course, Your Honor.
You indicated in your proffer that Mr. Cook's wife has been charged in this case in another case.
Yes, Your Honor.
And I would suspect that she was charged with something having to do with the injuries that Mr. Cook sustained.
Yes, Your Honor.
All right. I will tell you that part of the issue was that it appeared that Mr. Cook was not forthcoming at that, as I recall, at the he doesn't have to be, but the issue that the court also found some issue with is that Mr. Cook indicated that he didn't know how he got shot. And I understand he might have been protecting his wife, that is fine. The issue the court had with that is then you were around a weapon that you knew or should have known that you shouldn't have been around. And I understand that your argument is that Mr. Cook shouldn't have been around a weapon. You have just requested that one of the people that he could live with would be his wife. The court would be concerned, and if the court did consider giving Mr. Cook a bond under some conditions, that it sounds like him and his current spouse should not be together. And that it would be an issue of absolutely positively no contact. Would that be an issue with your client in this matter if the court were to consider his release on bond?
Absolutely not, Judge. If I may address that just very quickly.
Sure.
My request actually is that he be released to live with his mother, who lives out of county in Jackson County. That would be my first request. And I think that's appropriate. I know the court may have some concern because it's some distance away, but that actually may be a net positive. That is really our request. My intent in indicating that if you ordered it so he could live closer with his wife, they are amicable. There's no dispute, but I understand the court's concern. My preference would be that you allow him to live out of county in Jackson County with his mother. That case against his wife was resolved. It was dismissed actually in Cherokee County. But I think that the court's concern can be alleviated by allowing him to live in Jackson County with his mother.
Thank you, Mr. Cook. I'm sorry, Mr. Adams. I don't know.
Yes, ma'am.
Yeah, Mr. Gary. Good morning, sir.
Judge, just a few points. Mr. Adams stated that no crime had been committed, but the fact that the defendant's a prior convicted felon, that's either a violation of 1611-131 or 1611-133, felon in possession of a firearm or ammunition. So that in fact would have been a crime. He was not charged, I don't contest that, but it would have in fact been a crime. Your Honor, Mr. Adams stated, I'll repeat some of it, but in my chronology. On September 24th, 2025, the court denied Mr. Cook's prior motion for bond. In the court's September 24th, 2025 order denying defendant's bond, this honorable court explicitly found and stated that defendant Cook posed a significant risk of danger to the community if released on bond pursuant to OCGA 17-6-1E1B. On January 27, 2026, defendant Cook filed a renewed motion of bond. As I've just heard, I'd like to clarify, it's not a renewed motion for bond. It's a reconsideration. There's nothing new, and respectfully, counsel has proffered nothing new. This is the same information we had at the original hearing last year. Your Honor, OCGA 17-6-1E1 states that a court shall be authorized to release a person on bond if the court finds that a person, and then it states the four conditions that we normally know as the Ayala factors. In order to grant the bond requested today by the defendant, OCGA 17-6-1E requires the court find that the defendant doesn't pose a risk to any person. But the court specifically did and clearly stated so in its September 24th, 2025 order denying bond. Your Honor, nowhere in OCGA 17-6-1, nor anywhere else in the Georgia Code, respect to the court, authorize the court to release a person on bond if the court does not find all four of the conditions that we know as the Ayala factor. In fact, in Rooney v. State, yes ma'am, that's next, Rooney, 217 Georgia Appeals, 850, on page 852, 1995, the Georgia Court of Appeals in a Gwinnett County case held that after finding the defendant did not meet all four factors, the magistrate judge was not authorized to grant the defendant a bond, and then thereafter upheld Judge Oxendine's revocation of that bond. I've got a copy of that for the court. Your Honor, further, in Constantino, Constantino versus Warren, Warren, in 285 Georgia, 851 Division 2, 2009, and again in Myers versus St. Lawrence, Myers versus St. Lawrence, 289 Georgia, 240, 2011. The Georgia Supreme Court stated that the conjunctive and, that's A-N-D, within OCGA 17-6-1E1 indicated that the trial court may grant bond only if it finds that none of the four risk factors therein exist. I have a copy of those two cases for the court as well, Judge. Judge, respectfully, as we stand here today, as to this bond motion, that ship has sailed for the defendant. This honorable court has already found that defendant Cook does not meet the requirements of OCGA 17-6-1. Also, by analogy, with respect to defense counsel, in Snyderman, Sneiderman v. State, 329 Georgia Appeals, 359, a 2014 case, which was argued by defendant's present counsel, the Honorable Mr. Steele, the Court of Appeals stated that pursuant to the Georgia Supreme Court's decision in Burge, B-I-R-G-E v. State, 238 Georgia, page 88, 1976, that an appellate bond, which is also permitted by 17-6-1 under subparagraph G, also cannot be granted unless the defendant presents sufficient information, evidence, or argument to convince the trial court that none of the 4 factors enumerated in Burge applies. Your Honor, I've got both those cases for the court. Judge, pursuant to Constantino, Supreme Court of Georgia stated that this honorable court respectfully, given the prior order from September of 2025, does not have the authority pursuant to the statute to grant this defendant a bond. That order is in place. Now, I understand the court has the ability to strike that order if you want. But we went through a full hearing on that. Nothing new has been presented today to affect the court's order from September of 2025. Nothing. As we stand here right now, that order is still in place. Pursuant to the Supreme Court of Georgia, a bond can't be granted with that order in place. So where we're at now, I ask the court to dismiss the defendant's motion for renewed bond.
Thank you, Mr. Gary. Mr. Adams?
Your Honor, thank you. Where I disagree with the Honorable Mr. Gary's argument is that this court does have both the ability and the authority to reconsider its previous order, to reconsider the evidence in light of argument, of renewed argument. In the finding of in the court's order of September 24th of 2025, the court did in fact indicate that it believed from the evidence presented to the court that the defendant posed a significant risk of danger to the community if released on bond. However, the court has the authority to put in place strictures that addresses that concern to where the court would not consider him to be a significant risk of danger to the community if released on bond. And in doing so, or in making that determination, the court can in fact consider some of the things that I've mentioned previously. The court can in fact consider that he was originally released on bond, and those Iowa factors were considered. His bond was revoked because of a particular incident, and I understand the court heard that evidence, the court made a determination, but the court can also revisit that and make a determination that, for example, if you release him on bond and he is living out of county, he is living with his mother, that he is on ankle monitor, that he is on house arrest, that he has required check-ins with either the monitoring company or the court, or whatever Your Honor decides, that you can find that he is not a danger to the community as a result of those conditions that you put in place. Your Honor, at some point, reasonably, the defendant's continued detention becomes more than just pretrial detention, it becomes punishment. And I'm not saying anything to chastise the court, but I am asking the court to consider that. Oftentimes, I make the argument to courts, and courts say, well, what has changed? What have changed circumstances? And the courts, some courts might say, well, the fact that the defendant has been in custody for an extended period of time or will remain in custody for an extended period of time is not something that we should consider. I disagree. I would point again to the fact that we have announced our readiness to resolve this matter. We have done so. And it is no fault of ours that he will remain in custody for an additional year, but you do have the ability, you do have the authority to consider everything in this case and consider that he is in fact presumed innocent. I understand that these are serious charges against him, but he has not been convicted. That is why we're going to have a trial. But I ask you to consider all of those things. Consider releasing him and putting in place conditions that will, to where the court will not consider him to be a danger or risk of danger to the community if released. That's all.
Thank you, Mr. Adams. All right, I'm going to take this under consideration. I'll read the cases provided by the state and make my ruling forthwith. Parties may be excused. Thank you. Thank you, Mr. Adams.
Your Honor, thank you, Your Honor.
Thank you, Mr. Cook. Thank you, Mr. Gary.
That's it.
Mr. Smith is here. Are we ready to go forward with his